Really important that you have to tell me.
Yeah, I know a lot of
You thought-
things, Briggs.
Can I just finish my sentence?
No, you really can't because you're really disrespectful.
Oh, I'm the one that's interrupting you? Brandon Lee Allen? Brandon Lee Allen, 25 CR871. Are you Brandon Allen?
Yes, sir.
Come on up. Looks like he's been sleeping. You were here with your attorney, Mr. Dufler, and the state's attorney. Here's this file. Thank you very much. In 25 CR 871, you were charged with the third-degree felony of assault on a security officer, it states, on or about May 29th of 2025 in Jefferson County, Texas. That it carries with it up to 10 years in prison and a fine up to $10,000. Paragraph 2 of the indictment states that you were previously convicted of burglary of a habitation in the 252nd District Court next door on August 12th, 2020. If that is true, then if you're convicted of this third-degree felony of assault on a security officer, it then is enhanced to a second-degree felony punishment, which carries with it no less than 2 nor more than 20 years confinement in prison and a fine up to $10,000 can be assessed. Do you understand what you're facing with all of this, sir?
No, sir.
Okay. Okay. What do you have to say?
Judge, he has created a conflict of interest for me over the weekend. I received notice from the State Bar of Texas that he's filed a grievance against me.
Why?
He
Why?
says,
Because he's not a sufficient counsel and you are not my judge.
All right. What else? Anything else you want to say?
it just creates a conflict.
Well, see, what the thing is, he could pull that for everybody.
Understand?
I mean, he could go on for 100 years, like that's a master plan that doesn't work.
I don't know if that's his plan, but I know
Well, it doesn't
definitely
matter.
I cannot represent him.
Well, what do we do if he pulls the stunt in every case?
I can't answer
Well-
that for it, but I know.
Well, I mean,
know
that's not the
bar-
way it's meant to be. What's the good cause for this allegation?
Because he's
How did he do that?
he, when he puts me on the defensive by filing a grievance against me.
I know, but
he's made me.
but if they're in bad faith, that doesn't matter. He said he hadn't figured out some master plan that works. That doesn't matter. It won't work. Is there any good reason that he would have had to have filed that?
No, sir.
Yes.
Then I'm talking to him, sir, Mr. Rude. No, if it's not, then it's in bad faith, so it doesn't cancel. Because it can be, we can do this all day long, and that's not the plan where you stall. Who is it where would this end if they were able to do this? That's why it's not allowed. It's not allowed if it's in bad faith.
I don't know where he's going from here, but I do know that, it creates a conflict for me
I know, but who would it not create a conflict to in the scheme of the whole universe if this was allowed to be filed in bad faith?
I don't know what he's going to get for. He may never file a note. I don't
All
know.
right.
I don't know.
Well, maybe, do you want to represent yourself though in this?
Yes, I can. Yes.
All right.
Represent myself.
All right.
I'll say y'all.
All right. Then you will represent.
With my judge, Raquel West.
That's not the case you're in, son. You're in this court. So you're going to deal with me on this. That's the way it works.
Okay. Set a trial date.
Yeah. Do you know one thing? We want to make sure that you understand this. Generally, people who represent themselves don't do a real good, don't have a good success because generally the people who are the lawyers have gone to law school, have a law degree, have achieved a level of quality of education and passed the bar exam and have some experience to get in the felony court. All of those are important aspects in successfully handling a case. Do you understand that?
Yes, I've done all my research and I know all the laws.
Yeah. What is section 22 of the Texas Penal Code, if you know all the laws?
Section 22 of the Texas Penal Code. That has nothing to do with my case.
I'm asking you, said you know all the
I
laws.
said
What
I
is
know
that?
all the law to my case.
Mhm.
To my case. Like there's no proof beyond any reasonable doubt that I committed these acts with any criminal intent. If I put in a motion to quash these indictments would automatically be quashed.
Well, we'll do whatever it is you need to do, but you're asking for a jury trial though, right?
Yeah, set a trial there.
Then we'll let a jury make the decision. That's the way it works. But do you understand there are pros and cons? This is really important that you have to tell me.
Yeah, I know a lot of
You've
things,
thought of-
Briggs.
Can I just finish my sentence?
No, you really can't because you're really disrespectful.
Oh, I'm the one that's interrupting you? Okay. Oh, well, nonetheless, the law says you have to understand that there are,
I don't understand this case because I didn't do it.
that doesn't matter. The grand jury indicted you and had
Yeah, the grand
evidence.
jury has evidence that are
Are
non-sufficient.
you going to just interrupt all the time?
You're not.
Can I just, would you be just so kind and respectful just to let somebody complete their sentence and then you have a fair opportunity?
Beat this case.
All right, all right. If that's, we can do this all day long. But your final answer is you want to represent yourself. You understand?
Yes, sir. Yes, sir.
You're gonna be required to know the rules of evidence, the code of criminal procedure, the penal code, be prepared for that. If you don't know that, then generally people are at a disadvantage. Do you understand? All right. If you decide at any time you want to get somebody to help you, let me know immediately and we'll get it done immediately. Okay? All right. Anything else you want to add?
Nope.
All right, then we'll set it for trial. Thank you. That, Mr. Cawley, you have pleaded true to allegations 1 and 3 voluntarily, knowingly, intelligently. That is enough to grant this motion to revoke probation by a preponderance of the evidence or greater. Thus, your deferred or unadjudicated probation is hereby revoked. Earlier in this case, you pleaded guilty to this state jail felony of theft voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at that earlier plea hearing to find you guilty beyond a reasonable doubt. We deferred your finding of guilt and placed you on deferred or unadjudicated probation. Now that probation is revoked, I hereby find you guilty beyond a reasonable doubt of that state jail felony of theft. And I am following this agreement. You are hereby sentenced to confinement in the state jail for 1 year and given credit for all time served in conjunction with that case. Do you understand what has happened? Okay. What are you going to do now? When when this is behind you, you get out.
Give me a job.
Doing what?
Give me a job.
I mean, doing what? What kind of things do you do? You got an idea, I'm sure, right? Do you have a lot of talents? Do you have skills?
I like to play sports.
You like to
But
play
right now,
sports?
my brain I can't think straight right now.
Well, that's a fun. Have you thought about going to law school then? I'm just kidding you about that. I just wanted to see if the lawyers were listening. That was just, I went to law school too, but actually, if you're capable and that's what you want to do, there's an old saying, you can do anything with a law degree except practice medicine. It's a great degree. But what is it you like to do? For, that helps others, that makes a living, where you make a living. Mechanics, you fix things? No? Well, you gotta have a plan. Well, you're thinking about it. You're thinking about a plan. You gotta put one together and then do it. Okay. But the most important thing is stay out of trouble. Right. Okay. Good luck to you, sir.
Thank you. Good luck. Yeah.
Wow. Jimmy Ham gave me that